Usually when we picture the Supreme Court, we imagine this incredibly analog, almost frozen in time kind of space.
Oh, absolutely.
I mean, think about it. You've got the heavy oak paneling, the towering marble columns, stacks of physical paper briefs everywhere.
Right, and judges wearing robes that, haven't really changed style in centuries.
Exactly. It is the ultimate monument to human tradition. It's all about careful, methodical deliberation.
It's an environment that's specifically designed to feel timeless,
Mm.
deliberately slow, deliberately human.
Deliberately human, yeah. But today, we are shattering that image completely because we're looking at a collision between that ancient, deliberate world and the absolute fastest-moving technology in human history.
It's quite a contrast.
It really is. Today, we are going on a deep dive, unpacking a stack of analysis from a platform called Navi, and they are breaking down a newly released, highly consequential document from the Supreme Court.
Yes.
It is titled Legal Intelligence, Guidelines for AI in the Judiciary. And there is a massive ticking clock attached to this.
A very literal ticking clock, actually. Today is Saturday, June 13th, 2026, and the window to do anything about this document closes in exactly 1 week.
Okay, let's unpack this, because if you are listening to this right now and you aren't a lawyer and, you want a judge sitting on a bench somewhere, your first reaction is probably going to be, why should I care about internal judicial guidelines for AI?
Right.
I mean, it sounds like the most niche, dry, administrative legalese imaginable.
Which is a completely fair initial reaction. I mean, it sounds like an IT memo for court clerks, basically.
Exactly.
But what we are actually looking at, what Navi's analysis so brilliantly exposes, is that this document is a foundational blueprint. It is going to quietly but fundamentally shape the commercial technology that everyone uses.
Whether you ever step foot inside a courtroom or not.
Precisely.
So let's get into the mechanics of how an internal court memo actually does that, because Navi's first major insight centers on this concept of a due diligence ripple effect.
Yes, the ripple effect.
We're taking the rules meant for the courtroom, and we're dragging them straight into the corporate boardroom. Navi argues that because this document is issued under the support of the highest court of the land, it essentially reflects the definitive thoughts of the judiciary on how AI can be safely and legally used.
Right, and that specific phrase, thoughts of the judiciary, that's the operative mechanism here. It creates a baseline.
Okay.
The source points out that this becomes a due diligence standard for the rest of the private sector.
I was trying to wrap my head around how this actually works in practice, and the best analogy I could come up with is safety standards in extreme sports, like Formula One racing.
Oh, well, that's an interesting way to look at it.
Right, because in Formula One, the governing body invents these incredibly rigorous, highly engineered safety protocols, like the titanium halo that protects the driver's head.
Yeah, they mandate it because the environment is so extreme. The stakes are literally life and death.
Exactly. But what happens? The engineering principles required to build that halo eventually trickle down. The high-stakes rule becomes the baseline safety standard for the everyday sedan that you and I drive to the grocery store.
That is a highly effective way to look at it, especially when we talk about the motivation behind that trickle-down effect.
Yeah.
In Formula One, if a team decides, to skip building the halo and their driver gets hurt, they are held entirely liable because they ignored the governing body's established standard.
They didn't do their due diligence.
Exactly. And the courtroom is the ultimate high-stakes environment for truth, liberty, and financial liability.
But I'm going to push back here for a second because I really want to challenge this idea of the Supreme Court leading the charge.
Okay.
The tech industry is famous for its whole move fast and break things ethos. Iterate, deploy, patch it later. Meanwhile, the courts are famously slow. They are methodical. They look backward at precedent. So is the Supreme Court really driving the standard here? Or are they just frantically trying to catch up to a Silicon Valley train that left the station like 3 years ago?
What's fascinating here is that speed doesn't actually matter when you hold the ultimate authority on liability.
Wait, really?
Yeah. Even if the court moves at a glacial pace compared to a tech startup, the moment the court issues these guidelines, they create a definitive legal precedent.
Oh, I see.
Think about the mechanics of liability. If you are a private company, say a tech CEO or a board of directors, and you ignore these newly published standards, you are now knowingly operating outside the stated expectations of the highest court.
Ah, So it's not about the court out-innovating Silicon Valley. It's about the fear of the referee.
Precisely. Fear of the referee. If you deploy an AI tool and it hallucinates or it exhibits algorithmic bias and you get sued,
Right.
well, the opposing lawyer is going to stand up in court and point out that you didn't even meet the Supreme Court's own baseline for due diligence.
You're legally negligent.
You're sunk.
Wow. So corporate boards aren't reading this document because they are, fascinated by judicial theory. They were reading it for defensive engineering.
Yes.
They have to build to this standard just to protect themselves from future lawsuits.
Exactly. You are aligning your product with the ultimate arbiter of liability.
Okay, so if the fear of the referee forces the private sector to build a safer proverbial Formula One car who is actually turning the wrenches on this new technology, because the courts aren't building this software in-house, are they?
Oh, not at all. And that is the second massive realization in Navi's reporting. The private sector isn't just reading this document defensively. They have a massive direct financial stake in this framework.
Because they're the ones selling it.
Right. The courts are going to be buying these tools from private developers.
And here's the detail from the source that absolutely stopped me in my tracks. We aren't just talking about software that handles administrative requirements like, scheduling dockets or sorting PDFs.
And, it's far more involved than that.
The source specifically states that this AI will be for use by a judge in arriving at his decision. Let that sink in. This software is going to sit on the bench.
It is a profound shift.
There is an entire article in Navi's breakdown titled The Impact of SCAIV on AI Developers. SCAIV being the Supreme Court's AI framework. How does a document like this fundamentally alter the day-to-day job of a software developer?
It shifts their entire paradigm. The guidelines explicitly define, and I quote, what kind of AI usage is permitted and what is not.
Sure.
Normally, a software developer is optimizing for efficiency or user engagement or cost reduction. They're solving mathematical or logical puzzles.
Right, making an app faster or whatever.
Exactly. But when you are building a tool that a judge will use to arrive at a legal decision, the parameters change. You are suddenly encoding the parameters of justice.
Wait, hold on. Are we really expecting a 24-year-old software engineer in a tech hub to act as, a legal philosopher? That seems like a recipe for absolute disaster.
It does sound intimidating, but that is exactly why this framework exists. The burden isn't actually on the 24-year-old coder to invent a philosophy of justice.
Thank goodness.
Yeah. The burden is on the coder to build within the strict boundaries the court is establishing. The developer have to ensure that the algorithm's logic is entirely transparent.
Transparent how?
Well, a neural network is often described as a black box, right?
Yeah.
Data goes in, an answer comes out, but no one knows exactly how the math worked in the middle. The court is saying, we cannot accept a black box.
Because a judge can't just say, well, the computer said you're guilty, but I don't really know why.
Right. You can't have unexplainable verdicts. The developer has to engineer explainability into the system. The judge has to understand how the AI reached a specific conclusion so they can audit the logic against actual human law.
Which means digging into the actual meat of this regulatory blueprint is incredibly crucial. We know the stakes are sky high for the developers building it, and obviously for the public who will be subjected to the decisions made with it.
Yeah.
So what exactly is inside this document? Navi provides a list of 11 different articles that break down the Supreme Court's draft regulations. And by looking at these titles, we can essentially reverse engineer exactly what the Supreme Court is anxious about.
And how they plan to control it.
Right.
If we connect this to the bigger picture, this list of 11 articles acts as a structural map of the court's priorities.
Here's where it gets really interesting. Because some of these titles are dense, but they reveal so much about the mechanics of this rollout. Let's look at the first major one. Supreme Court preempts AI regulations in India.
That's a big one.
I need to pause right here. What does preemption actually mean in this context? How does a draft document from a court bypass the actual government passing a law?
It's a fascinating display of jurisdictional power. Usually we wait for a parliament or a Congress to pass a comprehensive technology bill, which, can take years of debate, lobbying, revision.
No, it takes forever.
Exactly.
Yeah.
But the judiciary operates its own branch of government. By unilaterally issuing guidelines for how AI is used inside the court system, they bypass all that legislative gridlock.
They just make their own rules.
Right. They aren't waiting for a national AI act to tell them what to do. They are setting the rules of the game for their own arena today. And as we discussed with the due diligence ripple effect, The moment the court sets a rule for itself, the commercial market is forced to adapt instantly.
It's a de facto regulation before the legislature even takes a vote.
Precisely.
That is a massive flex of institutional power. They're forcing the market's hand.
Okay, let's look at the next title on Navi's list because this one threw me completely.
Yeah.
It says, DGPSI AI reflects in the Supreme Court draft regulations.
Ah, yes.
Wait, DGPSI AI, before we move on, what exactly is that acronym hiding?
It is a mouthful, isn't it? DGPSI stands for the Data Governance and Protection Standard of India.
And Navi has actually been a major proponent of this specific data protection framework. What this title is telling us is that the Supreme Court isn't trying to invent a data privacy standard from scratch. They are actively integrating existing, rigorous data governance frameworks directly into the AI guidelines.
Why is that specific integration so critical, though?
Think about the sheer volume of highly sensitive data that flows through a Supreme Court. You have sealed corporate trade secrets, classified government documents, deeply personal witness testimonies.
Right.
If an AI is assisting a judge, it has to read all of that.
Oh, wow.
Yeah.
If I'm a tech company suing a rival for stealing my source code, I have to submit my source code to the court.
Exactly.
If the court's AI reads my source code, does it accidentally use it to train its public model? Does my proprietary code suddenly become an autocomplete suggestion for a random user on the internet?
And that is the nightmare scenario. By reflecting frameworks like DGPSI, the court is mandating strict data sandboxing.
Sandbox.
Yes. The AI must be able to process confidential information locally, assist the judge, and then completely wipe its short-term memory without ever phoning home to a centralized server or updating its broader weights.
That makes a lot of sense. The data protection obligations are basically foundational to the technology being allowed in the room.
Exactly. It's
Then-
non-negotiable.
Okay, moving down the list, we hit a cluster of articles that focus heavily on the human element. We have governance and regulations of AI in judiciary and governance of AI in judiciary. Uses.
This tells us the court recognizes that AI is not a set-it-and-forget-it technology. You don't just download Justice 2.0, double-click install, and walk out of the room.
Right, like an app update.
Exactly. The oversight requires a constant, unyielding human in the loop. The technology is a tool that must be continuously monitored and audited for drift.
Drift being when an AI slowly starts giving worse or more biased answers over time.
Precisely. The court is establishing a framework for continuous governance, not just a one-time security check at the door.
And that leads perfectly into the next title on Navi's list, which is developing competencies. And I have a major question about this.
Sure.
We just talked about how complex the data governance and algorithmic explainability is. How in the world do you train a 65-year-old judge who has spent 4 decades reading physical paper to interrogate a neural network?
That is arguably the most difficult practical challenge in this entire document. But notice the phrasing, developing competencies. It is an acknowledgement from the highest court that you cannot hand a highly advanced, potentially flawed AI tool to a judge or a clerk without fundamentally training them on its limitations.
So they don't need to learn Python or how to write code?
No, they don't need to be software engineers. They need to develop a new kind of literacy.
Okay.
They need to understand the concept of a hallucination. When an AI confidently invents a fake legal precedent that sounds perfectly real. The competency they're developing is a heightened form of skepticism.
Like fact-checking the machine.
Right. They must be trained to ask the AI, show me the underlying case law for this summary, and then manually verify it.
It's almost like training a senior detective on how to handle a brilliant but completely untrustworthy new informant. You listen to what they have to say, but you verify every single address they give you before you kick down a door.
That's a really great way to frame it. And establishing these competencies, these oversight committees, these data protections, it all requires immense coordination. Which brings us to the urgency of why we are discussing this right now, today.
Yes, the ticking clock. We are shifting from the theoretical breakdown of these 11 articles to the immediate practical reality facing you, the listener. I reminded you at the top of the show that today is Saturday, June 13th, 2026.
Right.
The source material stresses with very high urgency that public comments on these proposed guidelines must be submitted before June 20th, 2026.
That is just 1 week away. This isn't some abstract debate about a future that might happen in 10 years. The window to shape the rules of the game is closing in a matter of days.
And Navi's material specifically invites the public to participate. They provided these detailed summaries so that all the readers can proceed to form their own views and, if required, send their comments.
It's a call to action.
It really is. If you have thoughts on data protection or how algorithmic transparency should work or what kind of training a judge actually needs, you have a direct line to weigh in. I'm going to give you the email address provided in the text right now.
Grab a pen.
You need to email the member secretary at office.regcc@seeidotnic, I'll say that one more time, office.regcc@seeidotnic.
It is a remarkably rare opportunity for direct democratic input on a highly technical, highly influential standard before it's locked in.
It really is. But before we finish unpacking the timeline, I have to point out a detail from the Navi source text that is just, it's incredible. It is almost too ironic to be true.
Oh, I think I know what you're going to say.
To help people understand these incredibly dense legal regulations about controlling artificial intelligence, Nadev used an AI assistant to create the audio and video reviews of the articles.
I saw that in the source. They explicitly state, the articles have also been explained in terms of audio reviews and video reviews created by an AI assistant.
We are literally using artificial intelligence to summarize the rules governing artificial intelligence. It's like an Inception-level meta-irony. We've automated the oversight of the automation.
It is a brilliant meta layer.
Yeah.
But honestly, I appreciate what it demonstrates. It proves the very point the regulations are trying to make, AI is an undeniably powerful tool for synthesis.
Right.
It makes complex, impenetrable concepts accessible to the public at scale. But it still requires a framework. It still needs a human directing it. Furthermore, Navi notes in their breakdown that there are a few places where concerns have been expressed regarding the draft guidelines.
Which means the draft isn't flawless. It's a work in progress, and the people analyzing it can see the cracks.
Exactly. And this highlights why that June 20th deadline is so vital. Multiple perspectives enrich our understanding. We have the court's perspective on what they need. We have the private sector's perspective on what they can feasibly build. We have Navi's analytical perspective mapping it out.
But what's missing is the public.
Right. What's missing from the draft right now is the broader public's perspective. The fact that concerns have already been expressed means there is active room for debate. I highly urge you to review the materials, look at the mechanisms of data protection and oversight, and form your own independent views.
So what does this all mean? We have covered some massive ground today. We started with a document that looked like a sleepy internal IT memo for court clerks, and we've discovered that it is actually a defensive blueprint for the future of commercial technology.
It really is.
If you are a developer coding AI tools, your job description now unexpectedly includes wrestling with the parameters of legal jurisprudence and explainability. If you are a business owner adopting these tools, the Supreme Court is currently writing the baseline due diligence standard that will determine your legal liability for years to come.
It affects everyone.
And if you're just a curious learner, you are living through the exact moment where the ancient, deliberate world of law is attempting to build a harness for the fastest-moving technology in history.
And the window to speak up about how tight that harness should be is closing in just a few days.
It's an incredible moment in time. But before we wrap up today's deep dive, I want to leave you with one final thought, something to chew on long after you finish listening. We talked earlier about how this software isn't just for sorting paperwork. It's going to be used by a judge to assist in arriving at his decision. Right now, the AI is strictly an assistant, and the human judge has the final say. But think about the trajectory of this technology. If an AI's legal reasoning becomes so flawless, so incredibly comprehensive, and so impossibly fast that a judge consistently, time after time, relies on it to reach a verdict, at what point does the software stop being an assistant and start becoming the unseen gavel?